Good afternoon, viewers. Welcome to this fourth session of Companies Act Enable, Evaluate and Excel. Today we will discuss about the art of conducting general meetings other than e-voting, because for e-voting we'll have another session, and for this we have with us Dr. K.S. Ravichandran. Dr. Ravichandran is a practicing company secretary since 1994 and is the founder and managing partner of KSR and Company. Dr. Ravichandran is a registered insolvency professional. He has also served in the Indian Air Force for over 9 years. He is a specialist in a long list of areas which include mergers and acquisitions, JVs, company law, IPR, competition laws, corporate governance, etc. So, with this, I hand over to our expert today, Dr. K.S. Ravichandran.
Good evening, viewers. Art of conducting general meetings is the topic that we are going to discuss today. Under the Companies Act, when we say about general meetings, we do talk predominantly about general meetings which are annual general meetings and extraordinary general meetings. In the case of every company, annual general meeting is a statutory requirement, and once in a year there must be an annual general meeting is the law which has remained right from the 1956 Act with which we are familiar. Some of us are familiar, and 2013 Act also continues the same. So, annual general meeting is always conducted by every company with lot of arrangements and fanfare. It is annual general meeting to which most of the traditional shareholders look upon, and they probably make it a point to attend the annual general meeting in good number. The annual general meetings always occupy a substantial time of the company secretary and the people in the management who assist the company secretary in conducting the annual general meeting in a very smooth manner. In annual general meetings, typically the chairman of the company and the entire board of directors along with the company secretary will be present on the dais, and annual general meetings normally see a lengthy formality other than the statutory formality of reading out the notice or reading the auditor's report or going by the items to be transacted at the annual general meeting one by one. Strictly, if you look at the general ordinary items of business, it might not take much time for the AGM to be said to have been completed by putting to the resolutions for vote, let us say in a very simple manner by a show of hands, and then one by one take up the resolutions, and let us assume that there are only, let us say, 4 mandatory items, such as the adoption of accounts, the appointment of directors, the declaration of dividend, and the appointment or ratification of the auditors. In this type of very stereotyped meeting with these 4 mandatory items, you will not really require much of the time that is usually taken up at the time of annual general meetings. In some companies, like private companies, the retirement of directors by rotation will also not arise, and there may not be declaration of dividend also. So, fundamentally such meetings are reduced into a formality in the case of very closely held family companies or companies in the between the friends and partners, where these meetings are statutorily conducted just for the sake of completion of the statutory formality, because the directors themselves would have been involved in the affairs of the company, management of the affairs of the company. They will be very well aware of the financial transactions, financial position, state of affairs of the company, and the auditor would have interacted with the directors personally several times, and ultimately what happens at the AGM, if you look at it practically, is a matter of statutory formality. In such private companies, you will find typically the annual general meetings happening as a matter of fact inside the room, because there will be probably 2 members and 2 directors, and the items are simply passed as adoption of account and for auditor ratification or appointment. There may not be any big difficulty in whether dividend can be declared or not. All those things can be taken care at the time of finalizing the financial statements, approving the balance sheet and other financial statements. Adoption of accounts will become a formality, and therefore declaration of dividend also would have already got discussed between them, even if such a subject is coming up. Therefore, in private companies, annual general meetings do not really matter, because they are basically and fundamentally statutory formality. Therefore, where are we looking at the art of conducting general meetings? Sincerely speaking, in large corporations where number of members is also very large, and in public companies maybe they are unlisted but they have members, a good number of members, a crowd is expected at the venue of the annual general meeting. When a crowd is expected at a venue for the purpose of a certain meeting like an annual general meeting, it is always necessary that a discipline is brought about in every aspect connected with the meeting, and that is the reason why the lawmakers have thought it fit that such annual general meetings, or any general meetings for that matter, must be defined, must have certain features identified, certain characteristics defined, certain requirements brought into, so that the knowledge about the meeting, the business to be transacted at the meeting, and the manner in which the voting will take place, how the results are going to be construed, whether it is passed or not passed, with a particular manner in which the voting will take place, whether a resolution is passed or not, the decision, all these things are predefined by the Companies Act in a standard manner. The problem in standardization is normally it does not take care of certain situations that arise at the meeting. Any number of situations are possible, and in India, with more than I can say 100 years of company formation and meetings and procedures, there are n number of illustrations where meetings have thrown up new situations not contemplated by the lawmakers, and the lawmakers also do not want to encroach upon the field, because it is humanly impossible to think about what type of situations will arise in meetings. Therefore, generally, in order to give uniform time limit about knowledge of the meeting, a notice is prescribed by the statute. A notice of every meeting, a general meeting, must be issued to every person who is entered as a member of the company. This purpose is to tell all the members at the same time what is going to be transacted at the meeting. The notice definitely will contain the agenda, the items to be transacted at the AGM or any other general meeting. So, the main purpose of notice is to make it known to all the members in an equitable manner, at the same time, in the same manner, we can say simultaneously. Put all the members on notice that certain items of business are going to be transacted at a general meeting. Therefore, it is also an invitation to the members to come forward and attend the meeting and exercise their statutory voting rights. You know very well that voting rights vary depending upon the number of shares that a person holds. So, in case of members with huge stake, it will be necessary for such members to come forward, attend the meeting and exercise their voting rights, so that they are able to take decision making, they are able to participate in decision making in a proper manner, exercising their voting rights. And also the lawmakers have thought it fit that it should be a particular time limit, so that the members who are receiving the notices will be able to have sufficient time to understand, digest about what is going to be transacted at the AGM, and thereafter make sufficient enquiries in order to come prepared to make an informed decision while exercising their voting rights. So, therefore, the lawmakers have thought it fit that a particular length of notice is mandatory. So, therefore, what are the two things we are now able to understand? One is that there must be a notice. Two is that the notice must set out the items of business to be transacted. Three is that the notice must reach all the members in the same manner to all the members at the same time, and the time limit given is not less than 21 days in the case of most of the companies. As I already said, in the case of private companies with small number of shareholders, maybe starting from 2, it could be some 200 at the best, and this kind of closely held companies apart, there are thousands of, we can say thousands and thousands of unlisted public companies and listed companies where they have large number of members, and not less than 21 days is a very big task, because prior to 21 days the company secretary must be working overnight in order to bring about the entire thing together, understand the requirements for the whole of the year, because annual general meetings are once in a year. Therefore, a lot of preparatory work is going to be done, and not less than 21 days, and standard items of business have some reason. If it is any special item that is coming up, it can always be taken up separately. Therefore, at annual general meetings, the lawmakers have given a notice period, so that sufficient time it reaches the members, and the members across the country, whether they are in nearer to the registered office or far away from the registered office, are able to receive the notice, have sufficient time and understand the items to be transacted, make up their mind to attend the annual general meetings. Therefore, the two things are very clear. The third thing which the law has given as a matter of strict adherence and formality is, whenever you transact a business which are, for example, called as the ordinary business, as I was telling you in the beginning, the adoption of accounts, the appointment of directors, the declaration of dividend, appointment or ratification of auditors, these are all the 4 items of business that are known as ordinary items of business coming up at every annual general meeting. Now, apart from the ordinary items of business, there could be any other item of business which can be called special business. Whatever is not coming within the ordinary business is known as the special business. In relation to special business, the lawmakers have left it to the liberty and wisdom of the board of directors to decide whether a special business is required to be there at an AGM. If it is required, it is absolutely subject to the absolute discretion and wisdom of the board of directors to bring it up at the annual general meeting. Should they decide to bring a special business as part of annual general meeting, there will be what is known as an explanatory statement. An explanatory statement is an absolutely a very important document in the hands of the shareholders. when the shareholders receive the notice and they find there are some items which are special business, that is other than those 4 items of ordinary business, then they have a reason to read the explanatory statement and understand the purpose why a special business is being considered or going to be considered at the annual general meeting. So, all these regulatory requirements of giving notice to everyone, I mean every member, giving notice of 21 days, not less than 21 days, giving explanatory statement, these 3 things constitute a very important statutory formality, and the lawmakers have nicely thought it fit to give the members what they are expected to do when they exercise their voting rights, when they decide in favor of resolutions or against the resolutions. These things definitely give them sufficient time to take an informed decision, attend the meeting and vote accordingly in favor or against according to whatever is their decision. The 4th important thing is, it is not always possible for a member to be present at a particular date on which the annual general meeting is called. It is possible for the member to be preoccupied, it is possible for the members to see a sudden change in the schedule, there may be possibility, there may not be possibility. Therefore, the lawmakers have brought something known as proxy. A proxy is a person who can attend and vote in general meetings instead of the member himself. In most of the cases, other than private companies, a proxy need not be a member. A proxy need not be a member. So, it is not necessary that the members must always be coming in person and attending. Therefore, members who are from different parts of the country or outside the country, members who find it difficult to attend the AGM on the particular day, members who have initially thought they will be able to attend but they are not able to attend, members may not have financial strength to travel and spend money for attending the meetings at the registered office or venue which is there in the which is specified for the annual general meeting or other general meeting. So, they are having the freedom of statutory right of appointing a proxy and attending the meetings through a proxy. So, this is another important statutory requirement built within the provisions of the Act. So, we have seen the notice as an important requirement, we have seen the reaching of the notice with a sufficient time limit as an important requirement, we have seen explanations to be given to shareholders to understand the purpose of the special items of business, and we have seen members having the facility of attending the meeting in person or through proxy. So, these 4 things are the most important pillars of general body meetings. Apart from these 4 things, there could be any number of issues that crop up at the meeting that may arise due to business transacted, due to difficulties faced by the company, due to facts and circumstances. Those things have to be dealt with as required, as may be required. So, with respect to the 4 things like notice of meeting, the length of notice of meeting, the manner of sending the notice to the shareholders, the time at which it should be sent to the members, the explanation to be given, the facility of voting in person or through proxy, these apply to annual general meetings or extraordinary general meetings or any general meeting for that matter. So, this is a preface with respect to general meetings. Now, whether are they sufficient? A holistic question, a holistic answer must be found. What happens in general meetings? Is the chairman adequately equipped? Is it sufficient for the chairman if he comes and sits in the dais, runs through a printed typed agenda in front of him? Is it sufficient for the chairman to make a lecture or speech for a few minutes telling about the developments on business front to the shareholders and asking them to raise their hands one by one, for each item of business? No. There are several things that happen at the AGM, and as I told you, prior to the electronic voting era, annual general meetings are always seen as a very important once in a year affair in which members throng as if it is their personal family function. And that is why in annual general meetings there were procedures with respect to receiving the members, offering them refreshments. Sometimes companies offered gifts also, so that members go back for having come all the way and having participated in statutory items of business, having lent their support. There was a token of love and affection. Some gifts were also given at the meetings, and that gave an inducement for the members to travel all the way and understand about their companies. When members go back with some wisdom about the business of the company, when members come and raise queries and understand it better, so they are likely to be staying with the company, they are likely to be taking more informed decisions year by year. The annual general meetings and the procedures thereof have evolved over a period of time, and there is a purpose behind all these things. The annual general meetings offer a platform, a bridge between the shareholders and the top management and the board of directors to make it known to the shareholders what is the agenda for the company, what is in store for the company, what are the problems the company is facing, how the company has been able to achieve certain results, how certain things could not be achieved, what are the factors that have affected the business. All these opportunities of directly communicating to the members who attend is the most important point in every annual general meeting. And shareholders also have the direct right to go and ask for queries that they may have in the financial statements. I have seen typically annual general meetings conducted in several companies in my 24 years of practice. There have been cases where thousands of shareholders are meeting in auditoriums regulated by police force, and several questions, several issues, several chaotic situations, quarrelsome situations, protection is given. Such type of situations also we have seen in our practice. So all these things are not possible to be incorporated in a statute book and defined in a particular way to give guidance. They are all come by way of experience and practice. And in order to be ready for meeting such eventualities, in order to be ready for facing the issues that arise and thrashing it out and offering solutions, what is important is the rules of the game must be known to you. As far as possible, the reference to Secretarial standard would have told you there is a ready answer, there is a handy answer. The answer is in front of you for most of the questions. If you have 100 questions and you have the answers for that 100 questions, and the 101st will be the only thing you will be thinking at the floor of the house where the meeting takes place, which will put you at ease, which will give you a lot of comfort, which will give you a time for offering satisfactory solution, which will be able to calm down the situation in case there is any chaotic situation that prevails. So in meetings where large number of people attend, there are requirements for being prepared, and Secretarial standards, particularly SS2, has nicely introduced these answers in the form of various questions that have come up during the 100 years, we can say, of meetings. After all, every meeting is a place where people who have certain rights assemble together and discuss between them, come to some terms and take decisions in respect of certain matters. In large meetings, regulations are essential, and annual general meetings and extraordinary general meetings are no exception to that. It is the chairman who is supposed to be calling the shot. He will be the person who calls the shot, and he will be the person who can bring the meeting to order. So when you look at the provisions of the Companies Act and when you look at the provisions of the Secretarial standards, you will have a fair idea of generally what happens from start to finish. If you look at the construction of the statute as such, the scheme of the Companies Act as such, I can tell you that in respect of annual general meeting, a provision is there that it must be conducted once in a year. Notice must be given. Time during which meetings can be held is given. The days during which meetings should not be held is given. purpose for which it should be conducted mandatorily is given. So, what is left is only the additional items of business that the board can always in its wisdom bring it. Suppose a meeting could not be called, the annual general meeting of a company is not held, there is a default. Can the member who is aggrieved by the default do anything? Yes, statute nicely provides that approach the tribunal, go to the tribunal under 97, ask that the AGM was supposed to be held on so and so date, it has not been held. Why should not the member ask this? In LIC of India versus Escorts, way back, the Supreme Court of India clearly said what are the rights of members, and one of the most important rights of members is the right to vote, is the right to be informed about the financial affairs of the company, operations of the company, business of the company. If AGM is not held, two situations are possible. One, financial statements have already reached the shareholders and AGM could not be held. Financial statements have not been prepared, have not reached at all. How will you know about what happened in the company during the last financial year? As a member, are you not supposed to be vigilant? Are you not supposed to be informed? Are you not supposed to ensure that there is a proper management, there is a proper board of directors, and that board of directors do their duty properly? Therefore, while you are talking about rights of shareholders and members, you should also know that you have certain duties, and therefore it is not expected of a member to remain silent when he knows that he has not received the notice of the annual general meeting for the particular year. He has not been issued with the notice. He has not received the financial statements. He doesn't know about what happened to the company. Probably what he will do, normally you and me will write a letter to the registered office, at least in those days. Nowadays in email we might send probably a message and see whether there is any response, and you may not get any response if there is no responsible board, because if there is a responsible board, default would not have happened, AGM would have happened. If there is no responsible board, no response also is likely to come to your letters. Are you going to stop with that? Are you going to be silent after that? No, you are expected to go to the tribunal, and that is the reason why the law has thought it fit not to specify a qualification for you. The only qualification, you should be a member. A member of the company who finds that in his company the AGM has not been held, it is in default of holding annual general meeting, is entitled to knock the doors of the tribunal with a simple application, and the tribunal has powers to order an annual general meeting. So therefore, one is about the AGM, when it should be done, within what period, what should be the notice, what should be the time, what days it should not be held, and where it should be held, for what purpose. You see how the law has brought certainty with respect to these matters. And if it is not held, a remedy has also been given, and it is the duty of every member to avail the statutory right under 97 and ensure that the AGM is held. If necessary, they will be able to understand, if directors are not there, they will even be able to call an EGM and hold the appoint the directors, so that a proper annual general meeting could be held. See, these are all the provisions with which are required to be known as far as the annual general meeting is concerned. Then you have the extraordinary general meetings. Extraordinary general meetings have come because the statutory provisions under the Companies Act stipulate that certain things require resolutions of shareholders. Depending upon the developments in the company, depending upon the proposals approved by the board of directors, depending upon emerging situations and needs, company may from time to time require to transact certain things, require to get sanction of the shareholders for certain things. There are n number of items that are required to have approval of the shareholders. The shareholders approval is always given at a general body meeting in the form of resolutions which are ordinary resolutions, special resolutions. Now, in the case of an annual general meeting, which is a once in a year affair, specified items of business are transacted and special items of business are also added. But in the case of extraordinary general meeting, at any point of time, anything that is transacted is deemed to be a special item of business. The board is left in its absolute wisdom to call a general body meeting at any time whenever there is a subject matter that requires sanction or approval or clearance or whatever you call by the members of the company. So, therefore, the law has required resolutions of shareholders and law has enabled EGMs to be held. If this EGM provision is not there, there will be no meaning in requiring approvals of shareholders for various things. It cannot be said only at the annual general meetings. At all the time you have to wait for 1 year for getting clearances and approvals and sanctions. Therefore, only section 98 clearly says the board may call a general meeting, extraordinary general meeting we say, because it is other than the annual general meeting. The board may call a general meeting at any time. This is a very important provision, and at all times board can, whenever required, for a specified purpose. The specified purpose could be the purpose specified in the act or in any other law. For example, SEBI regulations, the listing regulations we have. The articles of association can also provide that for a particular proposal, for a particular decision, sanction of the shareholders is necessary. Therefore, EGMs may arise from time to time depending upon the proposals, depending upon the developments, depending upon specific provisions of the Companies Act, depending upon rules, depending upon regulations outside the Companies Act such as the LODR, depending upon articles of association. So, all these things definitely bring a need for general meetings throughout the year whenever, as and when required, other than the annual general meetings. And therefore, whenever we talk about annual general meeting, we also think that there are other meetings and they are called extraordinary general meetings. The notice provision, the length of notice, the proxy, the items of business, the explanatory statement, all these things are common to both the types of meetings, whether annual general meeting or extraordinary general meeting. Apart from extraordinary general meetings called and held by the board of directors, members themselves will be able to call an extraordinary general meeting. Members may be able to call an extraordinary general meeting whenever required. They may submit a requisition. However, the law has thought it fit not to permit members of having less qualification than what is prescribed to submit a requisition. Therefore, whenever members want to have a extraordinary general meeting called and held by the board, the members can approach the board of directors and deposit a requisition, and the requisition must be of a particular members having a particular qualification which is there in section 100, which says such number of members who are having such paid up capital, that is not less than 1/10 of the paid up capital of the company, not less than 1/10 of the paid up capital of the company that carries voting rights. Whenever we talk about right of members to vote, we should also remember a provision which is in 106 of the Companies Act. See, 106, notwithstanding anything contained in this act, the articles of the company may provide that no member shall exercise any voting rights in respect of shares which are registered in his name, on which any calls or other sums presently payable by him have not been paid, or in regard to which the company has exercised any right of lien. It is a very important provision. This is some practice area. This is a very important provision where the articles of association of the company will be absolutely right in saying that if a member is in default in paying the calls, if any amount is due from the member and he is not in paying that and he is in default, or his shares have been marked lien, or his shares on which the company has exercised its right of lien, voting rights are clipped. Of course, articles must provide. Therefore, whenever we say voting rights, we remember two important things. Number one is 47 of the Companies Act. 47 of the Companies Act talks about voting rights for equity shareholders as well as preference shareholders. Now, 47 is similar to 87 of the 1956 Act. 47 says, subject to provisions of section 43 and subject to provisions of section 50. It is very important. No, we are starting 47 and we are being directed to go to 43. 43 is about the kinds of share capital, and you would have already seen there can be shares, equity shares without voting rights. Preference shares also may not have voting rights, but it is subject to 47. So, when you read 47, you must remember you are talking about shares which are carrying voting rights. So, when you see 47, that is why the law has said you go to 43. In 43, there are shares with differential rights to voting. A share capital could be, equity share capital could be with voting rights and with differential voting rights also. So, therefore, whenever we talk about shareholders, members, voting rights, we remember it is possible for a company, a member of the company having shares. He is a member but does not have voting rights, because the shares he is holding carry no voting rights or shares with differential voting rights. Then 47 also requires you to see section 50. Subsection 2 of section 50 says a member of the company limited by shares shall not be entitled to any voting rights. Shall not be entitled to any voting rights in respect of the amount paid up by him until the amount has been called up. Therefore, in the case of a member who has paid the money for his shares prior to the company calling him to pay, advance calls, a member of the company shall not be entitled to any voting right by making payment in advance before the calls are made. So, now what are the three things we have seen is, we have seen one side 47 requiring you to travel to 43 and 43 bringing to light the shares with differential voting rights. Another side you have 50 subsection 2 particularly, where a member has paid money in advance before the calls are made, and for that portion of the paid up capital for which he has paid the money in advance, he will not be entitled to voting rights. Then I said 106. In 106 you have seen articles may provide that if a member is in default in payment of calls, or where there is a money due to the company on his shares and there is a company which has marked the lien on his shares, then also his voting rights may not be there. Subject to these three things, what are the voting rights? The voting rights, as 47 says, is every member holding equity shares shall have a right to vote on every resolution placed. What is the voting right? What is the measure of voting right is different. Voting right itself is specified in 47 clause 1a, that every member of a company limited by shares holding equity shares shall have a right to vote. This is not a measure of his voting right, this is the right per se, fundamental, on every resolution placed before the company. Before the company means before a general meeting of the company, not about board meetings. Before the company means before the general meeting of the company on every resolution. Therefore, voting right will arise only when resolutions are proposed to be passed and for that purpose they are placed before the company. Then come to clause 1b. His voting right on a poll, including e-voting, shall be in proportion to his share in the paid up equity share capital of the company. In proportion to his share in the paid up equity share capital of the company. That is why we say he holds 10% stake, 20% stake, 40% stake. Different stakes are given only because he has so much of stake in the paid up capital. The amount he has paid up as a proportion of the total paid up capital of the company gives his weight of size of his voting rights. Therefore, whenever we talk about voting rights, whenever a provision says depending upon voting rights, then that provision can be understood only after understanding 47 clause A clause B, 43, 50 subsection 2 and 106, which you may find in articles certain things. Now look at the preference share capital. In 1956 Act, there were two different types of voting rights falling upon the preference shareholders, depending upon whether they are cumulative or non-cumulative, depending upon the period for which the company is in default in payment of dividend. Whereas under 47, a company limited by shares, a shareholder holding preference shares, in respect of the preference share capital, he will have a right to vote. He will have a right to vote only on resolutions placed before the company which directly affect the rights attached to the preference shares. 47.2 must be understood in contradistinction with 47.1a. In the case of equity share capital, the law makes it very clear that a person holding equity shares has a right to vote on every resolution placed before the company. On the other hand, in the case of preference share capital, the preference shareholder has a right to vote only on resolutions placed before the company which directly affect the rights to attach to his preference shares. The rights attached to his preference shares, and second clause in subsection 2 is on any resolution relating to winding up of the company. Whenever there is a resolution for winding up of the company, it is deemed to be a resolution affecting the rights of preference shareholders. Therefore, a voluntary winding up, after the IBC, every member is looking at opportunities in voluntary winding up. They should know that if there is a preference capital, resolution of the preference share capital is also necessary. In fact, very recently, some of us would have probably been even amused to see that in a case like Tata, such a very big legal battle in corporate governance era, that preference capital was not taken into account when a petition was filed, and the company law tribunal had to rule that capital includes equity plus preference, and therefore preference capital must also be considered, and 10% qualification will be met only if the petitioner holds 10% of the equity as well as preference share capital. Now, in the case of 47(2), any resolution for the winding up of the company is deemed to be a resolution affecting the members, that is preference shareholders. Therefore, they have a right to vote. The third clause of 47(2) is for repayment or reduction of equity or preference share capital, and his voting right shall be, how much is the voting right of the preference shareholder? His voting right on a poll shall be in proportion to his share in the paid up preference share capital of the company. His voting right on a poll shall be in proportion to his share in the paid up preference share capital of the company. Therefore, you have equity share capital, you have preference share capital, and the 47(1) operate for equity shareholders, 47(2) operate for preference shareholders. However, there is a proviso. The proviso says the proportion of the voting rights of equity shareholders to the voting rights of preference shareholders shall be in the same proportion as the paid up capital in respect of equity shares bears to the paid up capital in respect of preference shares. Therefore, there is a, we can say, a measure of comparison between equity shares and the preference shares, and this proviso is supposed to be a special substantive separate provision. Actually, it is really not a proviso, because it does not work only for subsection 2, it works for the entire 47. So, it is a provision which is distinct and very important. And of course, only if preference share capital is there in the company, this 47(2) and this proviso will apply. If the company has only equity capital, this will not apply. Now, we have another proviso. This is a very important proviso. This says, where the dividend in respect of a class of preference shares has not been paid for a period of 2 years or more, such class of preference shareholders have a right on all the resolutions placed before the company. Therefore, if the company is in default in payment of dividend to the preference shareholders, and that default is continuing for a period of 2 years or more. Now, what is the difference between preference capital and equity share capital? There is no difference in terms of voting rights. In terms of voting rights, the preference shareholder also gets right to vote on all the resolutions placed before the company. Now, with this understanding of the voting rights, I will take you back to the requisitioned general meeting, in which we read that a shareholder who is having not less than 1/10 of the shares of the company, share capital of the company, as carries right of voting. What is important, you see, as carries the right of voting. Now, can there be a share which has no right to vote? There may be shares without any voting rights. There may be preference shares where there is no default and therefore there is no voting right at all. Wherever 100 is to be considered, requisition general body is to be considered. Wherever you are seeing whether the requisition is valid or not, you have to necessarily see whether the people, the members who have submitted the requisition on that date, whether they have 1/10 of such of the paid up capital of the company that carries right to vote. Therefore, in order to decide whether there is a valid requisition, you have to decide what is the paid up capital of the company, and such paid up capital should be that paid up capital which carries the right of voting. That is the reason why I took you through 106, 47, 43, 50. Of course, articles of association you have to read for 106 purposes. Therefore, in general meetings, whenever there is a board required general meeting, board called general meeting, There is absolutely no issue as regards these things. However, without the board calling a general meeting, there may be a requisition coming up from members, and therefore under the scheme of the Act, a requisitioned general meeting has to be called and held, failing which the members who are requisitionists themselves may proceed to call and hold the general meeting. In respect of requisition general meeting, there may not be a requirement for an explanatory statement to be given, because that is a duty of the board of directors under the Companies Act to give explanatory statement in respect of items of business which are coming under 102 of the Companies Act. Therefore, Companies Act will provide AGM, EGM and requisitioned EGM. Companies Act provides notice, period of meeting, time of meeting, day of meeting, agenda, explanatory statement for special items of business, and the role and the voting rights. All these things are essential with respect to every meeting of a company, every general meeting of a company. Apart from that, there are two more important things. What should be the quorum of a meeting, and who should conduct the meeting, who should chair the meeting, what are the rights of the chairman, what are the powers of the chairman. Practically these issues arise. Unlike the 1956 Act, 103 of the Companies Act has brought certain provisions consistent with the number of members, a higher quorum is provided. So therefore, whenever we talk about quorum for meetings, we must remember that if a proper quorum is not present, for instance, in a company, a public company, where the number of members is more than 1000. When you talk about members, we talk about preference shareholders, equity shareholders, everybody. Number of members as on the date of meeting is more than 1000. But up to 5,000, 15 members personally present, which means you can't call it a meeting unless at least 15 members are sitting in front of you. Of course, you may be one of the members, therefore, the chairman may count himself as a member present in person if he is holding shares, and therefore, there can be no meeting if a quorum is not present. Therefore, in order to look at a decision taken, in order to take it as a decision taken, a proper quorum is another mandatory need for, a statutory need for, a matter of substance, a matter of substantive law, not a procedural law. Like notice, quorum is also very important. We can therefore say without notice there is no validity of a general meeting. We can also say without quorum there is no validity for general meeting. Now, the other thing is the chairman. Who should be the chairman? How to elect the chairman, and what should he do? In case of adjournments, how he should be working, whether the meeting is required to be adjourned in a particular situation. In such a case, how he should be able to do the adjournment, and if meeting is adjourned, what will happen. These are all also provided by the lawmakers. This is about generally going about thinking and answering questions that may arise in your mind. There are certain things like poll, there are certain things like e-voting, postal ballot. I would simply put all these three things in one basket: voting by show of hands, voting by a poll, e-voting and postal ballot. All these are process, methods, we can say the manner in which the voting right of a member is exercised. Therefore, I do not really attach much importance to the way of voting, the manner of eliciting the decision, and the manner of allowing the member to exercise his right to vote. All that the law has thought it fit is to ensure that there is a duty cast upon the board of directors to ensure that all these modes as may apply from case to case are provided to the members, so that members are able to cast their voting rights and participate in the decision making, and the decision that is ultimately arrived at is a sound one. Now, generally in the meetings, general meetings, there are some very common things which are required to be remembered. One is, what is an ordinary resolution and what is a special resolution. The Act may provide certain things requiring a special resolution. For example, under section 62, a special resolution is necessary for a preferential allotment of shares. Under section 42, a special resolution is necessary for private placement of shares. These are all some of the instances where the law has introduced the need for a special resolution, and the law has also clearly defined what constitutes a special resolution and what constitutes an ordinary resolution. An ordinary resolution and special resolution you can see in 114 of the Companies Act, which says where the number of votes cast is more than the number of votes against, number of votes cast in favor exceeds the votes against, then it is called the ordinary resolution. In the case of special resolution, it is necessary to remember that in the notice of meeting itself, it should be specified that there is an intention to propose the resolution to be passed as a special resolution. This is very important. The members must know that it is a special resolution. For instance, you do not say it is a special resolution. You are having 26% of the capital. If you think it is a ordinary resolution, you might always stay at your home, because you thought after all 26% only you are having. Without you also the ordinary resolution will get passed. So why would I unnecessarily travel, go and do all these things? Suppose it is a special resolution and specifically stated in the notice, it gives you right to think about it. You may do some permutation and combination. For instance, you think promoters are holding, let us say, 21% of the capital. Now you think you are having more than about 15% of the capital. So voting right between promoters who are sure to attend and your voting right is just 21 and 15. So therefore, if you are putting 15% of votes against the resolution at the general body meeting in a special resolution, you have cast 15% of voting rights against the resolution. There must be not less than 3/4. There must be 3 times the votes against, which means if you have put 15% against, at least 45% must be in favor. So with promoters putting about 21% only, it is not going to be passed as a special resolution at all. They must be prepared to bring people who will vote for so that it is passed as a special resolution. So even with a 15% shareholding in your hand, you may be able to exercise a right which is more than the voting rights that you have. If you have 15%, you may be a formidable force at the general meeting in a case of a special resolution where there is something which the promoters would want to do, and you are a formidable force, a force to reckon with. Therefore, always whenever we talk about a special resolution, we must remember votes cast in favor must be 3 times more than the vote cast against. This is a very important rule we must remember at general meetings. Whenever at the time of planning for the general meeting itself, the boardroom discussion will have what are the permutation combinations and what could be the reaction to this meeting. If you see a recent study on how institutional voters, those who are probably the mutual funds and corporations like Life Insurance Corporation of India and all, how they have acted. Have they really been participating in the e-voting? Have they really been exercising their voting rights? If you see the track record for the last year and the previous year, you will find that it is a dismal one. Institutional voters may have not at all exercised their voting rights. Some of the institutions might have acted, but in one way or other, if they are for example, let us say a commercial bank having shares, if they exercise voting rights against, there as a banker they may have a stake in the same company, there may be some conflict. So, voting rights is an important subject whenever we talk about general meetings, and we should know what is ordinary resolution and what is special resolution, and articles may say certain things must be passed as a special resolution. Agreements incorporated in the articles may say somebody's vote is mandatory. An affirmative vote of an investor is mandatory for certain purposes, could have also been said in the articles of association. Therefore, when you talk about general meetings, you should have an idea, fair idea of what is. I have always had the difficulty of getting a proper answer whenever students who are passing out of this institute ACS exams, then when they are asked about what is the difference between special resolution and ordinary resolution, 114 is always a problem for them, because most of them get confused with 2/3 and 3/4. It is a simple rule, number of votes against and number of votes in favor. You should have an equation, and votes in favor must be not less than 3 times the votes against. So, therefore, fundamentally we should have an idea about the resolutions that are being placed before the shareholders, whether it is ordinary resolution or special resolution, whether the item of business is an ordinary business or special business, whether explanatory statement is required or not required, and what is the paid up capital with respect to each resolution. In respect of one resolution, paid up capital is different, in respect of another resolution, paid up capital may be different. Sometimes preference shareholders will have voting rights, sometimes preference shareholders might not have got voting rights. So, operation of 47, sometimes defaulting shareholders, sometimes shareholders on whose shares lien has been marked. So, all these things, including advance calls paid, you have to take care in conducting AGM. These things are very essential for the company secretary to visualize a host of factors like this, and when he prepares the notice and tries to issue the same, he should have already studied the shareholding pattern, the voting rights, the paid up capital, the situations, the e-voting, the postal ballot, what will be the result, how it should be done. So, there must be a lot of calculation that should be done, and that is going to be a very important task at the time of calling a general body meeting. And apart from that, there are certain ground rules. For example, when shareholders are bodies corporate and shareholders are institutions, you should have 113 complied with. A resolution of the board of directors of the body corporate or the governing body of the body corporate authorizing a representative is mandatory under 113, so that that particular corporation, body corporate, company, institution, society is permitted to exercise voting rights. And the resolution, if you see 113, it says in subsection 2, a person authorized by a resolution under subsection 1 shall be entitled to exercise the same rights and powers, including the right to vote by proxy, including the right to vote in postal ballot, etc. And he can always appoint a proxy also. That is the important thing there. One is he attends directly, then this is a person in present in person. If the authorized representative attends the meeting, it is a corporate body or company or entity present in person, and that authorized representative is also authorized to appoint a proxy by subsection 2 of section 113. Therefore, whenever your shareholding pattern reveals shares held by institutions, you should always check whether those institutions have submitted resolutions authorizing somebody to attend and vote or appoint proxy on their behalf for the shares held by them. The other thing is, normally we have 2 more provisions that come into play whenever we talk about AGM or EGM or whatever it is. You must remember that there may be members requiring circulation of resolutions. See, whenever they receive the notice, at that time they may issue a request for circulating resolutions. If you look at the section 111 of the Companies Act, section 111, it says a member, such number of members of course, as required under section 100, may give notice to the company for a resolution which may be moved, circulate, which have to be circulated to members, or any statement which has to be circulated. All these things may be given as per 111. So, this 111 is known as circulation of members resolution, and some time limit is given. See, you should also know that section 2, 111 2A, clause 1 says, in the case of a resolution requiring notice of a resolution. What is the meaning of notice of a resolution? The members who are submitting the requisition, of course being eligible, must say that a notice of that resolution proposed to be placed before the company at the general body meeting coming up shall be given to all the members. So, when there is a sufficient number of members who meet the qualification, who are eligible to submit such requisition, require the company to give notice of a resolution they propose to get moved at a general meeting, that is called notice of a resolution. That member is requesting the company to give the notice of the resolution, and if suppose members want to do so, they should do it not less than 6 weeks before the meeting. Now, you will have to remember that in the case of all the meetings, it is not going to be possible for members to give not less than 6 weeks, because sometime back we discussed about 21 days. 21 days is only 3 weeks. Sometimes you may have 4 weeks notice, but if there is a request for giving a notice of a resolution, the members must give that requisition not less than 6 weeks before the meeting. And then in the case of a statement, for example, the members give a requisition for circulating a statement, and that can be given 2 weeks before the meeting. So, where resolution 6 weeks, where it is only a circulation of a statement, after all you can print out and circulate at the meeting, it is only 2 weeks before the meeting. And now, in case after a copy of the requisition is delivered to the company by the eligible members under this provision 112 2A, after the depositing of the requisition for a notice of resolution, the company calls a general meeting. In such a case, the proviso under subsection 2 will apply. What it says is, provided that after a copy of the requisition requiring notice of resolution has been deposited at the registered office of the company, an annual general meeting is called on a date within 6 weeks. An annual general meeting, there is a specific mention about annual general meeting, and other words are not there. It is not a simple general meeting alone. An annual general meeting is called on a date within 6 weeks. Just a minute before we said for notice of resolution to be circulated 6 weeks notice is necessary. The requisition must be deposited at least 6 weeks before the meeting. And suppose a notice of a resolution as requested by the requisitionist is deposited, and immediately on receipt of the deposited, the company goes about calling an AGM. In such a case, this proviso will apply, and this 6 weeks time is waived in such a case. So, there is a requirement with respect to such things to be taken care at every general meeting. A requisition might come from eligible members, within the prescribed period for requiring a notice of resolution to be given to members. This resolution will be different from what the board has decided to be included in the agenda for the general body meeting. Or the members might come up and say, I want a statement to be circulated. Therefore, 111 is a provision which is also very important in the case of general meetings. You should have an idea. Otherwise, suddenly it will come, then you have to ring up the legal counsel or a company secretary in practice who is an expert in this area and ask, I have received 111. What shall I do at the 11th hour? Is it not? Such questions will always arise. There is one more provision which I would like to refer here, that is 115. In respect of certain matters, the law itself says a special notice must be given. So, whenever you prepare the agenda for a general meeting, remember to verify whether the item of business proposed to be transacted is something which requires, for example, 169, removal of directors. You will have a special notice request. 169 says, a company may by ordinary resolution remove a director, and it says in subsection 2, a special notice shall be required of any resolution to remove a director under this section. Therefore, 115 is another provision where a requirement for special resolution is necessary. Therefore, 115 is also a provision which you may have to remember in your mind whenever we talk about a general meeting. Circulation of members resolution 111 and special notice 115 are also to be considered. In respect of general meetings, particularly in respect of annual general meetings, you will have one more thing to be taken into account. Now, section 160, right of persons other than retiring directors to stand for directorship. Here, a person who is not a retiring director in terms of 152 shall, subject to the provisions of this Act, be eligible for appointment to the office of a director at any general meeting, and some member intending to propose him as a director not less than 14 days before the meeting. Therefore, you will have to remember that in some cases 160 will also apply. Where 160 is also applicable and not less than 14 days before the meeting a person has left at the registered office of the company a notice in writing signifying his candidature to be a director of the company. He is standing to be elected as a director. In such a case, he must have deposited this 1 lakh rupees or such higher amount as may be prescribed, and all these regulations also say that you will be alert, you may receive some notice of requisition with respect to a resolution to be given notice or moved, a statement to be circulated, or a special notice in respect of some matters like 169, or a request for standing as a candidate for becoming a director of the company. So, all these things are the various provisions of the Act which have to be remembered in conducting a general meeting. These are generally necessary for you to be equipped to handle any general body meeting in a particular way. Now, when we look at the Secretarial Standard number 2, SS2, having had an idea of the statutory scheme with respect to AGM, EGM, requisition to EGM and all, if you look at the Secretarial Standard, there are only some provisions which we remember, which we need to remember. The first and foremost thing in my opinion is, in SS2, the word meeting, the expression general meeting, the annual general meeting, extraordinary general meeting, they are the ones which are defined, and they say meeting, general meeting, AGM, EGM means a duly convened, held and conducted meeting of members. Therefore, SS2 applies to meetings of members provided they are duly convened, held and conducted, and it includes a general meeting, AGM or EGM, and requisitioned EGM too. However, the Secretarial standard says that where the meeting is called pursuant to an order of the court, like National Company Law Tribunal, then it says the meeting of such nature where it is called by an order of the court without prejudice to rules, regulations and directions prescribed for and orders of such courts, judicial forums, etc., the standard can be applied without prejudice. So, which means if the order says certain things to be done in a particular way, that standard must give way for that. Apart from that, in the case of certain meetings, for example AGM and all, national holiday meeting cannot be held. It is a very important provision which has been brought into by the new law, and you have a clear statement in 1.1 which I would like to refer here. A requisitioned general meeting shall not pertain to an item of business which is transactable, which can be transacted mandatorily by the postal ballot process. So, if there is anything which is to be done by postal ballot, it is not possible for the members who are giving a requisition for EGM under section 100. So, whenever it is 100, forget postal ballot items. This is general rule. Then, in the case of member, I have already said who is a member. A member is a person who is defined under section 2 within brackets 55. 255 says a member in relation to a company means the subscriber to the memorandum of association of a company, who shall be deemed to have agreed to become member of the company and on its registration shall be entered in the register as a member. And every other person who agrees in writing to become a member of the company and whose name is entered in the register. Every person holding shares in the company and who is entered as a beneficial owner in the records of a depository. Therefore, a member, when we talk about meeting of members, we should have an idea who is a member. Therefore, a reference to the definition read with 4.1e, which talks about a company which is having a share capital, and in the case of a company having share capital, the amount of share capital with which the company is going to be registered or incorporated, the number of shares each subscriber to the memorandum is agreeing to take, intends to take, these are mandatory to be provided in the memorandum. And in the case of company, section 43 we have already read, 44 is about shares and members. So, if you see a person in the case of a company with share capital, a person holding equity shares or preference shares is a member, and therefore, whenever we talk about Secretarial standard number 2, we must remember that there is a requirement to think about who is a member of the company. Who is a member of the company? This is a very important first question whenever we deal with members and meetings of members. Apart from that, certain provisions of the Secretarial standard will have to be taken into mind. One is 1.2.6. 1.2.6 talks about length of notice. In the case of a meeting, not less than 21 clear days is necessary. For the purpose of reckoning 21 days clear notice, the day of sending the notice and day of meeting shall not be counted. So therefore, you do not have any reason to refer to this Nagappa Chettiar versus Madras Race Club and all those earliest decisions of Madras High Court or that of the Karnataka High Court where 21 days is mandatory, 21 days is directory. All these are not required to be discussed now. By virtue of Secretarial standard, 21 days is mandatory except in the case of companies where there is an exemption, for example, private company. In a private company, some provisions are exempt, for example, 101 to 107. So, articles will provide in such cases. Barring those exceptions, generally speaking, 21 days will have to be given, 21 days clear notice must be given. And how do we construe what is clear notice? The trick is day of sending the notice and the day of the meeting. Both these days shall not be counted. And in the case of a company sending notice by post, courier, additional 2 days shall be provided for the service of notice. So, if it is email, probably we have no such additional 2 days requirement. In the case of an email, we do not have this additional 2 days notice. So, 1.2.6 remember with respect to notice. I have already told you the provisions like notice of meeting, explanatory statement, quorum, voting rights, manner of voting, special notice, authorizations to corporations, officers, government officers, etc., special notice and resolutions, circulation of resolutions, proxies. These are all very, very mandatory requirements of law. Therefore, any infirmity, any deficiency, any delay is going to touch upon the validity of the meeting itself. A general meeting, generally speaking, is a very elaborate exercise. As I told you in the beginning, an exercise which calls for organizing, logistics, so much of requirement and coordination must take place. Despite all the preparation, take it from me, you may have surprises, you may have shocks. So therefore, when you prepare, you must remember you do not render the meeting after all these efforts to become infructuous or invalid as a result of some omission to give notice within the time or within the prescribed time and all. Therefore, 1.2.6 must be remembered very carefully, very clearly, and must be adhered to without battling an eyelid. Now, 1.2.7 talks about shorter notice. Is it possible to have a resolution of the shareholders? Can we get approval of the company without waiting for these 21 days elaborate procedures? Yes, shorter notice is possible. What the law says for shorter notice, not less than 95% of the members who are entitled to vote at such meetings. Not less than 95% of the members who are entitled to vote at such meeting. If they give consent, such consent is sufficient to hold a meeting without this 21 days notice. It can be less than that. Of course, private companies, articles can provide less also. when we talk about 95%, I want to take you to this Companies Amendment Bill 2016. In Companies Amendment Bill 2016, one of the clauses is clause 28. I do not know if there is any change to this clause, because it was done long back after the expert committee. In one of the subgroups I was also a member. With respect to this 95% consent, the clause 28 says, in the case of annual general meeting, by not less than 95% of the members entitled to vote, and in the case of any other general meeting, by members of the company holding, if the company has a share capital not less than 95% of such part of the paid up capital as gives right to vote at the meeting. In the same clause, there is a difference in the language. In the case of annual general meeting, it says 95% of the members entitled to vote. When we talk about 95% of the members entitled to vote, practically it removes the possibility of shorter notice in the case of large corporations altogether. But in the case of extraordinary general meeting, if 95% of that part of the paid up capital that has voting rights, and they give consent, in the case of other general meeting, that is other than annual general meeting, there is a possibility even for large corporations, if they are able to get consent of 95% of the paid up capital, consent from such members. So, whenever we refer to 1.2.9 in respect of 1.2.7 of the SS2 in respect of shorter notice, we always keep in mind something is going to come in 2016 amendment bill. Then you have 1.2.9 AOB. Always this AOB is a very important subject. Any other item of business. At a general meeting, at a board meeting, everybody is probably aware in the CS fraternity that AOB was, I can say instead of is, was the norm. But Secretarial standard brought a beautiful discipline into this AOB business, and they have introduced how it will be allowed, because they do not want to remove it altogether. In SS2, when we talk about other than the items that are specified in the agenda, 1.2.9 makes it very clear, no item of business other than those specified in the notice, and those specifically permitted under the act to be taken up. For example, 21 days notice is necessary, but in the case of 160, 14 days notice is possible. A resolution for appointment of a director, for election of a director is possible. Therefore, 1.2.9 takes care of the important requirement, important question, whether any item other than those specified in the notice is possible. Yes, it is possible, except as stated in the act, it is not possible. Therefore, we must remember this. AOB has become again popular because of the Tata mystery case. AOB 1.29, we talk about general body meeting. That case was with respect to board meetings. So, 1.2.9 is something which we must remember. Then I would like to refer to 4.11, where it is said you have to give explanation at the board meeting with respect to absence of directors. The chairman is required to give some explanation. If a director is unable to attend the meeting, at least chairman should say, Mr. So and so, Mr. So and so are not able to be present for personal reasons or something like that. And this is one important requirement. Then 4.1.2 was discussed very often, and on the lighter side it was discussed wrongly also. 4.1.2 says directors who attend general meetings, the chairman, the company secretary, they have to be seated. That is only a requirement in order to put everybody on the dais, and things are smooth and it happens, and all are available who are probably, I will say, being an expert in litigations, I will say they are the respondents and they are the answering parties before the general body of shareholders, because they have been running the board of directors, the topmost governance body of the company, and they are supposed to be sitting in front and answering the members' queries. And that is the reason why 4.12 has thought it fit to ensure that all these people are sitting in front of the general vast body of shareholders who may raise questions, and they are the answering parties. And 4.2 and 4.3 talks about attendance of auditors, and these are very usually there, because when you talk about processes, when you talk about systems, particularly secretarial auditor, for the next AGM when he goes and reports, he must be able to know what was transpiring at the previous AGM. Then what is chairman's duty is nicely explained in 5.1. The chairman shall take the chair and conduct the meeting if he is not present within 15 minutes, and if he is unwilling to act as chairman, or if no director has been so designated, the director present at the meeting shall elect one of them. All these things are very good guidance for the chairman. In most of the meetings nowadays, wherever I advise the companies, I tell the chairman that you just have the SS2 by your hand, that's it. That is the we can say Bhagavad Gita so far as the general body is concerned, general body meetings are concerned. It will help them readily. You don't need to search which provision, 100 or 111 kya yaar, I forgot the provision and all, nothing doing. Simply refer SS2 5.1, 5.2, it says like this, there is a question, there is an answer, and it puts everybody at ease. And whenever you say according to so and so provision, according to so and so paragraph, it is also taken with a lot of weight. It is being taken up. Yes, there is a regulation, we can't do anything about it, we have to follow. So therefore, nicely 5.1 requires the chairman to do certain duties and powers, and 5.2 gives a very perspective for his speech. He is supposed to give an explanation of the objectives and implications. This comes at a very top level agenda of the governance. Chairman of the board, when he is sitting and commanding the meeting and conducting the meeting, he should have the preparedness. He cannot be a person who just walks in at the dais and looks at the agenda and reads it out. He is a person who must be able to make very nice statements after understanding the objective of the meeting, the resolutions proposed to be passed, what are the implications, what is in store for the company, how is it going to enhance the value of shareholders. In one sentence in 5.2, SS2 has captured very nicely a top level agenda in governance. It is a very important point. The chairman is supposed to come prepared. Of course, at the time of notice itself, he would have been very much part of it, he would have been consulted, he would have given guidance, he would have finalized it. However, at the meeting, when we talk about objective, when we talk about resolutions, when we talk about implications, it requires a little more than what is explained at the explanatory statement to be prepared. Therefore, I say that 5.2 has a salutary effect on governance, on promoting the governance. And then 5.3, of course, it is a matter of duty to avoid conflict of interest enshrined in 166 of the Companies Act, says even in general meeting, the chairman shall not propose a resolution in which he is deemed to be concerned. If he is interested, he can entrust the work to somebody else, is the paragraph under 5.3. So, it is very, very nicely it says, it is a very, we can say, an ethical part of it. It is a way of doing business in a nice way by saying, yes, I am interested, therefore, let me hand over the floor to my brother so and so, who will be leading the discussion on this point. That gives a lot of grace, and it puts the chairman at a different league, and he improves the stature of the chairman itself. That is how I think it should be in governance, in duties of directors. Across various jurisdictions, if you look at, the most important point is duty to avoid conflict of interest. And when the chairman says something, it will be followed by everybody, and therefore it is thought fit the chairman shall disclose his interest, he shall not propose even the item of resolution business which he is interested. Then you have 6.7, which is about revocation of proxies. See, this is a very interesting thing. Whenever a revocation of a proxy takes place, what will be the situation? A proxy, if a proxy has been appointed and another proxy comes up afterwards, a proxy later in time revokes the earlier proxy. A proxy is valid until written notice of revocation has been received before the commencement of the meeting. A proxy need not be informed of the revocation of proxy. A proxy need not be informed of the revocation of proxy. Then both are attending. 6.7.4, proxy is coming, member is also coming. In such a case, who would be allowed and who will be not allowed? These points give you at the gate itself a clarity. A CS or a person who is handling the a meeting should be having this as a very nice guidance. Suppose both are coming, there is always a possibility that 6.7.4 is known to you. You will immediately say, okay, let the member attend the meeting, let the proxy be deemed to have been vacated, revoked automatically. So, it is a very nice provision. And 7.3, we talk about showing show of hands. Even now we talk about show of hands. In certain cases it applies, and related party, wherever there is a resolution in which a related party is involved, is not entitled to vote, is what is written in 7.5.2 and 7.6. I would like to refer 7.6. It is also with respect to meetings of members unless otherwise provided in the articles. In the event of equality of votes, quite possible there is equality of votes, whether on show of hands or on electronically or on a poll, whatever be the manner of voting, as I told you, show of hands or whatever, poll, postal ballot, etc., etc. Electronically, e-voting. The chairman of the meeting shall have a second and casting vote. Now, unless he knows that there is an equality of voting, even in e-voting, how will the chairman, if he wants to have the resolution passed, because it is in the interest of the company, how will he put the second or casting vote? 7.6 has to be considered with very, very, we can say, holistic thought. In the event of equality of votes, which means at the time the second or casting vote is exercised by the chairman, he must know that there is an equality of votes in relation to a resolution. In the event of equality of votes only this power comes. Therefore, when it comes, what is it? Who should give? All are clarified under 7.6, and it says whether on a show of hands or e-voting or on a poll. Therefore, 7.6 presupposes a declaration of result, post declaration of result, second or casting vote. Post declaration of result arising from show of hands, e-voting or poll. In the case of e-voting, in the case of hands, in the case of poll, whatever it is, at the end of the day, if there is an equality of voting and the chairman wants to pass have the resolution passed in the interest of the company, it is very well within his right, use 7.6, the weapon in his hand, in the equality of votes, and remove the deadlock. When the chairman has entrusted the conduct of proceedings in respect of a particular item in which he is interested, then a person who takes the chair that is disinterested, we can say, that person has the second or casting vote. So, situations are captured nicely. Then I would like to straight away go, because even as per the topic I do not need to talk about e-voting, but I want to devote 1 or 2 minutes on para number 10. Look at para number 10. These are very important questions. This is not a question for the students alone, it is a question for everyone. See para number 10, withdrawal of resolution. Is it allowed? The listing agreement, the listing regulation says wherever there is an e-voting, there is no question of withdrawal and all. Resolutions for items of business which are likely to affect the market price of securities shall not be withdrawn. Lot of application of mind is required. Whether it is likely to affect the market price of securities is a question involved. Any resolution proposed for consideration through e-voting shall not be withdrawn. Rules are clearly spelt out in para 10. Similarly, I want to talk about para 11, cancelling the resolutions. A resolution passed at a meeting shall not be rescinded. Otherwise, by a resolution passed in a subsequent meeting, meeting means general meetings. So, you cannot simply cancel it. A resolution, see, somebody will think, okay, I have passed the resolution and immediately it requires to be cancelled, and you have the 21 days notice and elaborate arrangements to be made. Once more everything has to be gone into, or at least a postal ballot must be introduced, and what is this, shareholders will think that there is a mockery of it. It is not so. A resolution passed need not be implemented. You can always get it cancelled if necessary. It is the board of directors who are ultimately the people with power collectively, as per 179, to exercise the rights of the company, to exercise the powers of the company. Therefore, even after a resolution is passed by the general body, it is not necessary that board should always get it cancelled first. It can also be done at a later date. There is no real hurry in this. Therefore, the standard has thought it fit not to prescribe any lesser, we can say, ritual, length of time, etc., for rescinding or cancelling of resolutions. Rescinding of resolutions, we can also see an alliteration there. It is rhyming. Resolutions, rescinding. Then you have modifications of resolutions. That is under 12, a modification which do not change the purpose of the resolution materially. Application of mind. The CS, it is better for the company secretary in employment to have a deeper thought on this and write the note specifically saying that if there is a modification proposal coming up, you shall clearly bring to attention para number 12 and say whether it is causing a change to the purpose in any material way to the resolution proposed, and that is how the modification is required to be done. Of course, no modification to any resolution, text of the resolution shall be made in the case of anything which alters the substance of the resolution except some typographical errors, etc. And for that also correction is by the chairman. No modification shall be made to any resolution which has already been put to vote by e-voting, because e-voting would have commenced. Apart from that, 14 is something which we all know, gifts are not allowed, and adjournments are nicely discussed more than what is written in 103, in respect of this 101 adjournments are there. There are some provisions. If you talk about 103 on quorum, you will see adjournment with respect to quorum not being present, and there is a proviso and how it should be dealt with. Now, instead of looking at 103, you will have ease of reference under para number 15 with respect to adjournments, and thereafter all that secretarial standard provides is the minutes, inspection, custody, copies, extracts. So, with this I would like to go into the questions, if any, which might have come up, and after answering the questions we can call it a day, I believe.
We have received quite a few questions.
Okay.
I'll go one after the other.
What I suggest is, suppose I have already answered.
Yeah, that I would.
You need not repeat
that.
those questions.
Yeah. Whether the proof of sending notice is also to be maintained when sent by post or courier, or only when it is sent through electronic mode.
Proof of notice is see, I have dealt with several cases of oppression, mismanagement. Most important questions that come up is that a notice is not properly given. In fact, in one of the reported judgments, I have been able to argue that 48 hours was not given So, we go to the extent of showing the time at which the registered post is sent, or the post or courier is given, and the time of the meeting, time of commencement of the meeting. So, therefore, always whether secretarial standard requires you to maintain or not, as a matter of standard practice, it is always necessary you maintain a proof with respect to dispatch, particularly when we say 21 days notice, and other than email you have additional 2 days. Is it not very essential that these papers are kept with the company for a reasonable period of time? I am also required to refer to one particular standard. Let me take you to that standard now. One second. I have a provision with respect to preservation. What it says is, office copies of notices, scrutinizers report, related papers shall be preserved in good order in physical or electronic form as long as they remain current and for 8 financial years, whichever is later, and may be destroyed thereafter with the approval board. So, there is some guidance available in Secretarial Standard 18. Plus, why do we look at from a different general angle? Why do we need proof of a notice? And that too when you put it in a box, in a post box, ordinary box. A proof is necessary for the purpose of ensuring that integrity and validity of the resolution is not challenged, and if challenged, you are able to throw before the court of law the evidence in your hand, so that the actions taken by the board of directors do not come up to be tested at a court of law for any purposes. It is very important that we have the proof as much as possible for the purpose of ensuring that these things do not disturb the management of the affairs of the company. Therefore, a litigation avoidance tool is a proof, and whenever proof is there, you will be able to keep peace with you, and you don't need to worry about any number of disgruntled shareholders or other elements challenging the validity of resolutions passed. Next question.
Whether the same procedure are to be followed for AGMs in government companies?
No, AGMs in government company or any other company are the same, one and the same. General meetings have to be conducted in the same way. There is only exemption for government companies, private companies and Section 8 companies to the extent specified in the notification 5/6/2015. That's all.
What is the role of a PCS appointed as a scrutinizer for an NCLT convened general meeting, NCLT convened meeting for demerger of a private company?
In fact, I have answered this already. I said that Secretarial Standard in the preface very clearly says that where there is a meeting which is ordered by a tribunal, the order and the procedure specified, if any, will apply. Without prejudice, that only the Secretarial Standards will apply. A PCS definitely has a very good role. See, in demergers and mergers, you must be able to identify the person. You can have creditors meeting, you can have unsecured creditors meeting, you can have preference shareholders meeting, equity shareholders meeting, class of shareholders and class of creditors meeting. So, therefore, it is possible for a PCS to extend complete support. In fact, there are cases where a PCS was the chairman of the meeting. In court order, even before the NCLT came into force, there have been cases of mergers and demergers where court has appointed even me as the chairman of meetings. So, therefore, you can conduct the meeting itself, and everything which is applicable. What is important is you should have the law, the Secretarial Standard and the Articles of Association and the order of the NCLT requirements. Place it before the members and get the voting done. That's it.
If there is no special business, does the company require to add a para in the notes of the notice that since there is no special business, that there is no special business?
It is better not to write all these things. If it is there, you provide an explanatory statement, otherwise no.
There are two questions regarding proxies. Can a member act as a proxy for another member And is a proxy counted for quorum?
No, for quorum always I have already said
It is
personally present. A proxy being a member for shares which is different from the member who appointed. So therefore you are a proxy only so far as those shares are concerned. Therefore you can't be counted as two members.
And is there any maximum limit as to number of members to whom a person can be a proxy?
Yeah, that is provided already.
In the
This
standards.
105 and the Secretarial Standard very clearly
Says
mention
50.
about proxies, and I have told you to just refer to the proxies as a very important thing, because proxies are coming up in courts several times. Validity of proxy, inspection of proxies, because proxies may have number of votes.
Shorter notice is allowed, but the financial statements, can they also be sent at a shorter period than 21 days?
Yeah, that point is taken care and it has been addressed. Previously in 1956 Act you had this 219 and there was a provision for that, and that has been now addressed.
With regard to gifts at general meetings, are vouchers like snack boxes, restaurant vouchers, they are also prohibited.
All forms of gifts are prohibited except giving water and refreshments.
In respect of private companies, can the AOA prescribe that the proxy should be a member?
Certainly.
Okay. I think we've covered the questions that are here as such in your address.
Okay.
So I think with this, I think we'll call it a close. Thank you, viewers, for your overwhelming response and the number of questions which through the session Dr. Ravichandran has addressed, and we'll be happy to receive your feedback on this session. With this, I'll like to present a small memento to Dr. Ravichandran. Thank you.
Vanakkam.